Judgment, item number 20.
In view of the above discussion, the present writ petition is disposed of with a direction to the respondents 1, 2, 5, 6 and 8 to pay compensation of 3 lakhs each to the petitioner 1 and 2 and rupees 5 lakhs to the petitioner number 3 within a period of 6 months from the date of receipt of a copy of this order.
May I please, Lordship? Lordship, I beg to mention hearing item number 13, Lordship. Lordship, if this matter can be fixed next week, that is on 28th.
On the prayer of the learned PP Nagaland, list the matter after a week.
On Thursday, madam. I fixed it, madam.
On Thursday.
Yes, madam.
Okay,
28th.
give the date, no?
28.
28/5, yes. Yes.
Right, madam.
The prayer is not objected to by the opposite parties. Yes.
Right, madam.
May I please, Your Lordship?
Yes.
Maybe please to mention hearing item number 10 to 12, Your Lordship. 10 to 12. Your Lordship, if this matter can come after 3 weeks.
Yes, 3 weeks.
Item number 10 to 12, Your Lordship.
Ms. Livika prays for listing the matter after 3 weeks for hearing as she has personal difficulties. Stop.
No, Your Lordship, the matter is pending in the apex, Your Lordship, in division bench, Your Lordship. We are awaiting that one, Your Lordship. Similar matter, Your Lordship, yes.
Then you say the prayer is made by learned government advocate Ms. Livika that similar matters are pending before the division bench and accordingly prays for listing the matters after 3 weeks. Huh? Okay. Learned counsel for the petitioner, Mrs. Surgeon's present, list after 3 weeks. Yes.
Hey, please, my lady. Lady, I beg to mention hearing item number 18.
18, yes.
Lady, here we have received the paper book just last week, and it's a bulky paper book. So if we may be granted some time, and if this matter can come up again on the 4th of June for hearing.
4th June is okay. Learned counsel for the appellant, Ms. Lucino, submits that the paper book has been received only a few days back and she needs to go through the same stuff and therefore prays for listing the matter on 4/6/2026. So praise a lot, list on 4/6. The learned counsel, Ms. Asina Longkamar, appearing for the respondent number.
For respondents on behalf of Mr. Akrujusi.
They'll be appearing for all the
Behalf of
respondents.
such and such has no objections. Yes.
Obligement.
Please, Lordship, I beg to mention hearing item number 19.
19.
I
Yes.
pray that this matter may be listed after 2 weeks. The leading
After
counsel.
2 weeks.
Yes, Your Lordship.
Yes.
The leading counsel is in this post.
Learned counsel, Ms. Menusino, praying on behalf of the leading counsel, Mr. L. Iralu, prays for listing the matter after 3 weeks as the
After
leading
2
counsel
weeks.
is in this post. So this prayer is allowed, list after 3 weeks.
The
Yes.
paper book is ready.
Paper book is ready. Okay. You have received?
Yes, we have received. I've taken the consent of the government.
Okay.
Please, Your Lordship. Your Lordship, I beg to mention item number 3. I'm for the respondent 1. I'm filing my affidavit this morning only.
Respondent 1.
Yes, Your Lordship.
So when have
The
you
matter can
received a
come out
copy?
on, Your Lordship, we are yet to receive a copy, Your Lordship.
Yes,
If the
I'll
matter
serve,
can come up on 11, Your Lordship, 11th of June.
11/6.
Yes, Your Lordship.
Okay. Learned Counsel Ms. Nancy Lotta, appearing for Respondent 1, submits that she has filed her counter affidavit this morning, and a copy will be served during the course of the day. So, accordingly, she prays for listing the matter after some time. So, Learned Counsel Mr. M. Solo, appearing for the petitioner, prays that the matter may be listed on 11/6. Prayers are list on 11/6.
Lordship, Marshal.
Much obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 4.
4.
If we may be granted 2 weeks' time to file our counter affidavit.
2 weeks.
Yes, Your Lordship.
Yes, Learned Counsel Ms. Such and Such, appearing for.
Here I am for the respondent.
Okay.
Lordship, I am yet to receive the service copy.
Okay, you have not served.
I have already served, Your Lordship.
Lordship, we have not received the service copy.
Anyway, you give him an extra copy today.
No, while filing, sir is not available, so I have served.
I have only one copy with me. Since it's served to one of my colleagues.
You serve one copy today? No
Yes, Your
problem.
Lordship.
Mr. Learned Counsel for the petitioner, Ms. Taipul is present. So, Learned Counsel, Ms. Such and Such. Your name?
Uzumnila.
Your name is here. Uzun appearing for the respondent 1.
Respondent number 2.
Respondent number 2. Prays for 2 weeks' time to file their objection. So, the learned PP, Mr. V. Jumomi, also submits that he has not received a service copy, extra copy of the petition. So, the learned counsel for the petitioner shall serve a copy of the petition on the learned government advocate during the course of the day. So, and thereafter the matter may be listed after 2 weeks as prayed for. Okay.
Lordship, there is interim.
The interim order passed earlier shall continue till the next date. Yes.
For admission, item number 1.
May I please, Your Lordship?
May it please, my Lordship.
Yes.
Lordship, may kindly refer to previous order, that is 19/2/2026, passed by this Honorable Court. The order of this Honorable Court is very clear.
What is this regularization?
No, Lordship, the respondent went to Supreme Court for granting of scale pay to the
Scale pay.
petitioners.
File has been processed to the Chief Secretary's office, submitted to the. Yes, what is the stage?
Your Lordship, I received an instruction, though I have not received a hard copy, Your Lordship. I've received that the respondent, they have actively processed the matter and it is before the cabinet, Your Lordship.
No, Lordship.
Yes, Your Lordship, that is the instruction I received, Your Lordship. It's before the cabinet.
Placed before this Honorable Court, the status of this case before this Honorable Court. Now he's saying that it
you
is.
submit that status report in written in form of affidavit.
Yes, Your Lordship, I will do that. Because of the personal difficulties, Your Lordship, unable to do, I'll file it within a day or two, Your Lordship.
I have
after
it.
receiving
I have it, Lordship. It is they who should place before this Honorable Court, but I have it. Again, in the next, they will bring the same thing, making same excuses. Now, I received it last evening. Now, if we go by this, Supreme Court dismissed.
Again, seek the legal advice.
They think that this
Proposal and resubmit to the cabinet.
this cabinet thinks that they are above the Supreme Court direction. They filed appeal, it was dismissed. They filed review, it was dismissed. And now, because of this, I filed in 2022, and now this is pursuing the contempt. Now, last order, my lord, is very clear that they say that they will bring before this Honorable Court the compliance order. Now, again, they are seeking the
Since the response.
legal advice of the Advocate General. Is Advocate General above the Supreme Court, Lordship? What is this?
See, the contemners here, what can they do? The contemners here have processed, they have done what they have to do.
Yes, Your Lordship.
The respondents here, they are the
One,
chief secretary, must be,
the Executive Secretary, the Commissioner Secretary, Your Lordship.
secretary PNR.
Yes, Your Lordship.
So have you seen this cabinet minutes?
No, Your Lordship, what I have been informed is that it is placed before the cabinet for compliance. They have done the part, they have sent it, Your Lord, before the cabinet, Your Lordship. But I am yet to receive that hard copy, Your Lordship.
You get it and then you file it in the form of affidavit.
Yes, that I will do, Your Lordship. I will do, Your
A
Lordship.
week, within a week.
Yes, within a week I can do, Your Lordship. But in view of this, they were seeking for some time, Your Lordship.
No, you first
Since
file your
before the
affidavit
cabinet.
to consider
Okay, fine. Okay, Your Lordship. Okay, Lordship.
the petitioners. Means that Imami is present. Stop. Learned counsel. You are appearing for all the respondents.
Yes, Your Lordship. Yes, Your Lordship.
Appears for all the respondents. Stop. On 19/2/2026, the learned counsel for the respondents had submitted that the case of the petitioners has been processed in file and that the finance department is working on the matter for compliance of the court's order, and accordingly the learned counsel had prayed for 3 weeks time to comply with the direction of this court. Stop. In spite of the objections raised by the petitioners, this court allowed the respondents another 3 weeks time to complete the process. So today, when the matter is called, the learned counsel for the petitioner has placed a copy of the cabinet meeting minutes held on 6th May 2026, wherein the cabinet had directed the concerned department to seek the legal advice of the learned Advocate General Nagaland on the proposal and to resubmit to the cabinet. Stop. Learned counsel for the respondent submits that she is yet to get the hard copy of the said meeting minutes and prays that she may be given 1 week's time to place the same on record by way of affidavit. So, prayer is allowed least after 1 week, within which time, before which time the learned counsel for the respondents shall file the affidavit regarding the status update. Yes.
Much
Okay.
obliged.
Give it back.
Much obliged.
For admission, item number 2.
Yes.
May I please, Lordship? Lordship, on the last date, which was on 12/5/2026, last Tuesday, IA number 4, condition was condoned, and IA number 5, which was stay, was also stayed, my lord. On the condition that the 50% of the awarded amount should be deposited, which we are yet to do, my lord, because the office of the micro office here in Kohima, the person who's looking in charge is out of
Anyway,
station.
we'll admit this appeal.
My lord, my lord.
Because appeal is yet to be admitted, isn't it?
Yes, my lord. TCR also may be called.
The instant appeal under section 173 of the MV Act has been preferred against the impugned judgment and order dated 2/9/2025 passed by the learned MSCT Dimapur in MSC case number 44 of 2024. So, heard learned counsel for the appellant, Mr. Medo Vero. So, learned counsel, Ms. Mika Aye has entered appearance for the claimant respondents number.
Lordship, I'm for respondent 4 and 5.
Oh, not claimants, okay.
No, Lordship.
Has entered appearance for respondent 4 and 5. Stop. None appears for you're yet to take steps, na?
I've already taken steps. He has
taken
entered
steps.
appearance, my lord. Z Kulnu. He's only selecting
It's
court number 1.
in the court
Oh,
one,
okay.
Lordship.
It is submitted that by the, it is submitted at the bar that the respondents 1, 2 and 3 are represented by Z Kulno. Stop. Accordingly, no formal notice is called for. Stop. The main grounds taken by the appellant in the instant appeal is that What's that?
Page number
What
6.
is the main that the tribunal failed to take into consideration that the claimants had failed to establish negligence of the offending vehicle. In the present case, there was no charge sheet, no FIR, and no materials regarding the investigation into the accident. So the matter was decided solely on the basis of GD entry, which did not record any finding regarding the negligence of the offending vehicle. Stop. That is the main ground, I think.
That is the main ground, my lord.
Stop. Admit the appeal. Call for the records from the court of from the learned MS City, Dimapur, Nagaland. List after receipt of the trial court records. Okay, you're here. So just put his name Z Pulno for the for the respondent number 1, 2, and 3.
Yes.
Claimant respondents 1, 2, and 3.
Much obliged, my lord.
For admission, item number 5.
Yes.
Lordship, we have filed a compliance affidavit in the month of April. And Lordship, by DC has, by an order dated 33/2026, has disposed of the
33/2026.
starting from page
Page 13.
13. And the relevant portion will be starting from page 21. Repeat portion, the last three paragraph. Starting from
Okay, what was the direction of this court? To dispose of only, I think?
Lordship.
To dispose the case within
Page 12.
90 days.
Page 12. Paragraph 12.
Accordingly, the appeal is matter afresh, and after hearing the parties are okay, then compliance is done, so we'll have to
Your
close it.
Lordship, this is the second contempt, series of second contempt.
No, we only have to look at the direction. What was the
Logic.
direction?
Logic.
So direction is complied with. The direction doesn't say that you give the order in favor of the respondent or in favor of the petitioners. Nothing like that.
And all these delay
So after
process,
this, now there is another cause of action, which is a reason. So it's up to you to take further steps
Lordship.
in the
My-
for the
my
appropriate
humble
forum.
prayer to this honorable court is to impose a exemplary cost on the respondent because of this 6 months in addition to the 3 month given by this honorable court.
Lordship, we have already complied with the court's
The
order.
compliance is already there, so.
By
You see,
disposing
Dimapur
of the
continuously taking this matter into delayed process all because of this.
Lordship,
this
we
evidence
cannot
matter.
adjudicate the matter, Lordship. Since Lordship, the direction was
There may be many reasons which we cannot go into at this, in this petition. Stop. Learned, no.
Knowingly they are
The
making-
petitioner is present in person. Stop. Learned counsel Mr. V. Jimami appears for the sole
Sole
respondent. Sole respondent. Stop. The direction passed in WPC
213 of 2022.
WPC 213 of 2022, right order dated 26/6/2025 was was directed to the Revenue Court / Deputy Commissioner Dimapur to hear the matter afresh and to arrive at findings with regard to all the issues and thereafter dispose of the same by a speaking order. Stop. By filing the compliance affidavit, the sole respondent has enclosed the order dated 33/2026 passed in the instant case, by which the case of the petitioner was dismissed as not maintainable before the concerned forum, and the petitioner was given the liberty to approach the competent civil court to determine the issues relating to title and / or adverse possession, if so advised, in accordance with law. Stop. This court finds that the direction of this court in WPC 213 of 2022 has been complied with, and accordingly this petition is closed and disposed of.
For addition, item number 6.
Yes, complaints done.
My lady, I received the instructions on 18 of May 2026. I may be allowed to read paras 3 and 4. The PNR department, after thorough examination of the report submitted by the committee, issue an office memorandum dated 5 March 25 granting scale of pay as per ROP 2015 to all such category of employees appointed prior to 6 June 2016 with effect from 1/4/2025. Further, a notification was also issued on the same day deeming such employees to be casual employees, thus bringing them within the purview of the Work Charge and Casual Employees Regulation Act 2001 and the regularization scheme so notified under the provisions of the Act. These measures are thus intended to not only assure such employees the rights and benefits accorded to government employee, but also the right to full pension benefits for the entirety of the period of service rendered. Then number 4, accordingly, all such employees who meet the prescribed criteria across all departments, including the petitioner, have been granted scale of pay. On the matter regarding the grant of arrears to the petitioners, it may be mentioned that there is no provision for a prospective effect of the OM dated 5/3/2025, nor is there any provision for the grant of arrears. However, if it were to be considered as per the ROP 2015 granted to the petitioner, the arrear amount arrived at calculated from the dates of filing the writ petition would be in the negative for all the petitioners, and in fact the government may have to recover the outstanding amount from the petitioner. A copy of the showing the calculation of arrears is enclosed as Annexure 4. Lordship, if you come to Annexure 4, the Annexure 4
here.
Yes, Annexure 4. Annexure 4, the next page, because this one is 2 cases. The next page is writ petition filed on 19/3/2020, Council and 37 others. So, Lordship, we have worked it out, and the calculation comes to negative, the arrears.
So the prayer in the writ petition was for arrears.
Yes, directed to pay the minimum scale of pay as that of the regular employee, Lordship, from the date of filing of the writ petition.
So that has been paid.
So we have paid the scale of pay as per the latest 2015 ROP. So when we calculated the 2015 ROP, the arrear comes to, from the date of filing of the judgment is filing of the writ petition is 19/3/2022. So it comes to negative.
Lordship, the
Let us see
relevant
the
portion is
judgment
page
once.
42. Lordship.
Page 42, para 34. In view of the aforesaid judgment and order of the division bench of this court, as well as the judgment and order of the single bench of this court and the apex court, I am of the considered opinion that this repetition can be disposed of by directing the respondent authorities to pay the minimum of the pay scale at the lowest rate in the regular pay scale, extended to the regular employee holding the same post with effect from the date of filing the writ petition 19/3/2022. So we have given the scale of pay as per the ROP 2015. So when we calculated the area from 19/3/2022 as per the ROP 2015, it comes to negative, Lordship.
Gotcha. So that means with effect, even if you give with effect from
From
19/3/2022,
Yes.
there is nothing
No
to be paid.
area, yes, yes. Here it's shown, yes. However, the government were more gracious that by the latest OM, they will come under the Work Charge and Casual Employees Act. So if they serve for a certain period, they will be regularized and they are to
They will
get
be covered
pension.
by that OM.
Yes, yes,
regularization
yes,
OM.
yes, yes.
Then what more is left?
No, Lordship, if I
Have
may,
you seen
Lordship,
this
here.
calculation? Have you consulted your
No, Lordship,
clients?
they served this morning. No,
Okay,
only,
okay.
yes, Lordship. And in fact, Lordship, the order is very clear to give a minimum scale, pay scale as that of the regular employee.
No,
And
that's
Lordship-
why they have
Lordship, they have
calculated like that accordingly.
2015, that is only for the, that was recently created only, Lordship. Only
No,
after the disposal
only
of this,
in Lordship,
this
if
rate,
you see
Lordship.
the
And that is for
para-
casual and temporary employees,
Annexure 3
Lordship.
also, the 2015 is already there. Annexure 3, scheme for regularization and absorption of work charge and casual employees and revision of pay and wages. Annexure 3,
Annexure 3 in your compilation.
yes, yes, Annexure 3. This is the
Scheme,
scheme, yes, scheme. And if your lordship come to the office memorandum, serial number 2. My apology that I have not given the pagination, my lady.
Revision of pay.
Yes, yeah, work charge
slash
employees.
wages of work charge employees.
Yes, so the pay scale of all work charge employees who are presently growing scale pay as per ROP 1993 and who shall continue as work charge employees shall be revised as under with effect from 1/1/2015, subject to condition indicated below. So this is the ROP 2015. Yes.
See, if you are not satisfied, you have to assail this memorandum where the conditions have been set out and then the calculation which they have made.
Lordship, since we were served now only, allow me to take some instruction, Lordship.
You take instruction, otherwise I don't see anything remaining here in this contempt. Anyway, learned counsel for the petitioner, Miss Mikai is present. So the learned counsel for the respondents, Miss V. Shukre, has produced an instruction dated 18 May 2026, wherein the respondents have stated that the direction of this court has been complied with. In the said instructions, the respondents have also shown, where is that? Shown the calculation of the arrear statement in respect of the petitioners herein. A copy of the same has been served to the counsel for the petitioner, and the learned counsel submits that she may be allowed to go through the same and agrees that she may be allowed to go through the same and receive further instructions from the petitioners. So, how much least after 2 weeks?
2 weeks,
Least after 2 weeks. Let's pray.
Much obliged, Lordship.
You can take this back. Actually, it's better if you file it in the form of affidavit, isn't it?
Okay, I can do that, yes.
Let them file.
Okay.
The learned counsel for the respondent, Ms. V. Shukri, is also directed to file the said instruction in the form of affidavit within a week from today.
For admission, item number 7.
May I please, Your Lordship? Lordship, here in this matter, we have already received affidavit filed by respondent number 2 and 3. So in their affidavit, they have stated that they have already complied with the direction by submitting my documents for verification by the DLVC. and they have duly forwarded it to the PNR department. My lord, unfortunately, respondent 1, being Commissioner Secretary PNR, they are yet to enter appearance. So if I may be allowed to take steps by way of Dusty.
And I believe there is a new incumbent also now, Commissioner and Secretary PNR. Learned Counsel for the petitioner, Ms. Grace Namki, is present and submits that the affidavit on behalf of respondent number 2 and 3 has been received, wherein it has been stated that the case of the petitioner has been processed and put up to the state level verification committee in the Department of PNR. So she therefore submits that the respondent number 1, that steps on the respondent number 1 may be allowed to be taken. Stop. However, at this stage, she has also submitted that if in case the present incumbent has been transferred out, she may be also allowed to file an IA to implete the new Commissioner Secretary of PNR Nagaland Kohima. So prayers allowed. The petitioner shall do the needful within a week from today. List the matter after 2 weeks.
Much obliged, Lordship.
For admission, item number 8.
Service awarded.
Delay.
No, Your Lordship.
Learned Counsel for the applicant, Mr. Kedovi, is present. Stop. The service on the respondents has been taken by speed post, and the return service report is awaited. So please, after 3 weeks, awaiting service on the respondents.
Your Lordship, similar cases, item number 20, 24 and 25 yesterday case was listed, and these 3 are analogous case, Your Lordship. And as per yesterday also wrote that matter has been listed for after 3 weeks.
After 3 weeks.
Yeah, so that all the 3 matters may come together in the next.
But here the condonation is there now.
No. There's no continue.
This is not condonation.
Yes, Your Lordship.
Okay. It's filed on time.
Yes, Your Lordship.
Learned Counsel for the appellant also submits that similar matters are pending before this court. That arising out of the same accident.
Yes, Your Lordship.
That 2 MAC appeals
Yes, Lordship.
arising out of the same accident are already pending before this court. So, being MAC number, do you know
8
the
and 9.
numbers? MAC number 8 and 9 of 2026. He prays that this matter may be listed along with the MAC 8 and 9,
10.
8 and
9,
10.
10. Yes, 8, 9.
8
Yes,
and 9, you're
yes,
sure?
yes,
8 and 9 of 2026. So list accordingly, okay? Along with 8 and 9. Yes.
Very good.
I don't know, yesterday we have given they were listed after 2 weeks.
3 weeks.
3 weeks, okay.
For admission, item number 9.
Please, Your Lordship. Lordship, this is an application under Section 5 of the Indian Limitation Act, praying for condonation of 163 days in filing the accompanying review petition 1 of 2026. However, Lordship, there was a small error in calculation, and the actual delay is 157 days, not 163. Hence, the delay for condonation would be 157 days.
157.
Yes, Lordship.
Lordship, may I just point out,
Yes.
due to some communication gap, I did not receive the IA on time, so I could not file any objection. But Lordship, if I just take one,
What is the review for?
Lordship, I just wanted to point out, I want to I don't want to contest the condonation.
That's why.
Yes.
We can just condone it and go to
Take
the
up
main
the review
on
petition.
merit. I think that is
Lordship,
better.
the review petition is an appeal in disguise.
Anyway, we'll see. The present application under Section 5, the Indian Limitation Act, has been filed praying for condonation of delay of 157.
57. Yes, Lordship.
Okay. But in the petition, it's 163.
Yes, Lordship, there's an error.
Means
It's okay,
we
it's
are
okay.
condoning 163.
Yes. Even if it's 163, we're condoning it, so it's okay. Delay of 163 days in filing the connected review petition number 1 of 2026. Stop. The learned counsel for the petitioner, Ms. Such and such. Stop. The main reasons for the delay has been set out
In para 7, Lordship.
in paragraph
7.
7 of the application. Stop. Learned counsel for the respondents, Mr. Apok Pongonar, is present and has
That's
submitted
1 to
that-
4.
for respondent number 1 to 4 is present and submits that he has no objections regarding the delay. So this court has perused the reasons for the delay and find that sufficient cause has been shown, and therefore the delay of 163 days is condoned and the application is allowed. Then in the main case,
By letter friend agrees, we can take up the review.
we can hear you if you're ready.
Lordship. Lordship, if the Lordship may kindly turn to page 6 of my review petition of review petition 1 of
What about
2026.
5 and 6? Did they
Even in
appear?
the
Even in the
appeal,
they did not
they,
appear.
they did not appear.
Okay.
And this court had passed the order. So I think
Okay.
their presence may be dispensed.
Yes.
Para 6, Lordship, if I may be allowed to read.
Para 6.
Yes, Lordship. That the learned counsel submits that in view of the IA Civil 68 of 2025 for continuation of delay of 94 days, explanations of the delay has been unintentional and not due to willful negligence of default on the part, but the court has dismissed the IA with a view that this court has observed that there is no cogent explanation whatsoever regarding the delay from 26/11/2024 to 05/03/2025 and also from 07/04/2025 to 02/05/2025 when the appeal was finally filed. This court is also of the view that the period between 26/11/2024 to 05/03/2025 and 07/04/2025 to 02/05/2025 does not concern the applicants, but delay has been caused during preparation of the appeal by the counsel. Accordingly, the court is not inclined to allow the present application. Lordship, this is the order by which the IA was dismissed.
Condemnation of delay.
Yes, Lordship. Para 7, if I
No,
may
but when the court has come to that conclusion, we cannot change it now in the review.
That's what.
If you feel that there is something wrong with that, then you have to prefer an appeal.
Lordship, in my humble submission, the ingredients to invoke
See,
the review jurisdiction has not
That's
been
why
laid out.
review, unless something new has come up which could not have been brought to the notice of the court during the hearing, only in such cases, and certain matters which was not in your knowledge, and you wish to bring that to the knowledge of the court, that is, these are the only grounds on which review can be maintained.
My only
But
submission
here,
is,
you're against the finding of the court.
Yes, to reverse the
Yes,
decision.
to reverse the finding of the court. So that
That's
cannot
an
be.
a bill in disguise.
Lordship, my only submission is that the
If
petition,
you are aggrieved, you file an appeal. Yes. Electronic counsel for the petitioner, Ms. Such and such. Stop. The instant application under Order 47, Rule 1, read with Section 114 of the CPC, has been filed praying for review of the order dated 7/8/2025, passed by this court in IA Civil number 68/2025, in connection with MSc Appeal 8 of 2025. Stop. Para. The learned counsel for the petitioner submits that in the IA Civil 68 of 2025, there was a prayer for continuation of delay of 94 days, and the court has dismissed the same by observing that there is no cogent explanation regarding the delay from 26/11/2024 to 5/3/2025, and also from 7/4/2025 to 2/5/2025. Stop. The court was also of the view, this court was also of the view that the period between 26/11/24 to 5/3/25 and 7/4/25 to 2/5/25 does not concern the applicants, but delay has been caused during the preparation of the appeal by the counsel. Stop. Para. Learned counsel has submitted that the said observation was incorrect, factually incorrect, as the delay was caused by the applicant themselves and not by the counsel. That is your submission, isn't it? And not by the counsel. However, yes.
The petitioner had taken all necessary steps. So, Lordship, my submission is that the delay was not it occurred due to circumstances attributable to the counsel, not the applicant.
Oh, okay. But you delete that, huh? The petition, but learned counsel for the petitioner said that this is an incorrect conclusion, as the delay was caused due to the preparation of the appeal by the counsel and not by the applicant. However, the court has wrongly come to the conclusion that the delay was caused due to the negligence of the applicants.
Not in specific terms.
Para. And in view of the said submission, learned counsel praised that the order dated 7/8/2025 in IA 68 of 2025, arising out of MSc Appeal 8 of 2025, may be recalled/reviewed by taking into consideration the facts as stated above. Stop. Para. Learned counsel, Mr. Apok Pongono, appearing for the claimant respondents number 1 to 4, submits that this review application is actually an appeal in disguise, as the petitioner has assailed the order dated 7/8/2025 on the ground that the court had come to a wrong conclusion. Stop. He has submitted that the petitioner has not been able to show that this court has not been able to show that has not been able to show any grounds for this court to exercise its review jurisdiction. He has submitted that the grounds of that the review jurisdiction is very limited, and the present review application should be dismissed, as no grounds for review has been made out. That's all. Stop. Para. This court has considered the submission of the counsels and perused the application and the pleadings thereof. Stop. Grounds for review are very limited, as stated by the learned counsel for the respondent, and And it is settled law that unless certain facts slash materials which could not be which would have been which should have been considered in the previous application but could not be brought to the knowledge of the court by the petitioner, and upon finding by the court that such materials should have been considered, only in such cases a review is maintainable. Stop. In the present case, it is found that there is no such new material or facts produced by the petitioner, and the petitioner is mainly concerned and aggrieved by the finding of the court. So, accordingly, this review is dismissed as not maintainable. Yes, Lordship.
Much obliged. For hearing, item numbers 14 and 15.
All parties are ready.
Two items. May I pray that Lordship may take up item second one, that is 15.
So that,
Same agreement order. Prohibitions happen five.
so that is WPC 52.
Before opening the file, brief background in 2 minutes time I was able to summarize.
Okay.
The petitioner, the two did petition, they refer as petitioners. You were appointed on contract basis on 3/6/2016. That is 3 days before a government pen order of 6/6/2016, which Lordship is aware that from that date there is complete ban on the fish appointment under the government of Nagaland.
On paper.
Yes, maybe. Now, we catch up the flight by 3 minutes.
Okay.
3 days before the ban order, we were appointed.
You were appointed.
On 3/6/2016.
Okay.
And then we continued, extension orders were given from time to time. In the extension order, one condition is that the extension is paid subject to the recommendation of the NPC. The selected candidates will be appointed on the basis of the recommendation of the PPC. That was a condition, so it continued from time to time. Trouble started when government issued a memorandum that was on 15th of March. Government has issued a notification, office memorandum in 2024, by which 16 March, I should not have forget that date. Somebody's birthday is on 12. So 16 March.
16 March 2024.
And since that office memorandum says that the persons who have completed 10 years of continuous service and a top contract, they can be regularized, that is in class 1 and 2, Gazette post. They can be regularized as a one technician. And then 2 instructions were given. Maybe that may have alarmed some unemployed persons. So under the name and style of Nagaland Technical Combined
Technical Association.
Technical Association of Nagaland.
CITAN, yes.
He submitted an application with representation to the Director of Soil and Water Conservation. the petitioners were appointed as JSC or Junior Soil Conservation Officers. In short, JSC. So,
Junior Soil Conservation Officer,
yes,
JSCO.
yes. And director was pressurized by that resolution because they have given a deadline. If by 11th of March, these two persons are not amended, we will lock the office of the Nagaland. We applied
Soil
a
Conservation.
general law. So that was the treatment given to the director. Director may have been frightened by that for resolution, and then he has forwarded that with the recommendation to terminate the two petitioners in the two separate petitions. And basing on that, of course, we have mentioned so many things, but our service has been terminated. During that time, first, the petitioner in WPC in 1915 filed a case for regularization of my service. That was also pending. So those associations, NGO may have been frightened that I may be regularized, so something has to be done. So with that, they have approached the department, the director has forwarded and recommended for termination of our services. So we have challenged that in the presentation. Government, by filing down there, has said that no, you have filled up the post on the basis of the recommendation of the NPC. Therefore, we have no right. So termination has been tried to justify by that reason. During the tendency of the writ petition, I have filed RTA application because it was removed in an unreasonable manner. Termination was not in accordance with law. Therefore, we sought RTA application. Who were appointed in those vacancies where we were holding the post and our PIMs, total strength of vacancies, how many posts of requisition during our appointment from this period to that period, all detailed information were furnished by the NPC, which demonstrates, by the department, which demonstrates that nobody has been appointed against the post held by 12 of us. That is one. And then the PIMs, that is mandatory since 6/6/2016. Because all information will be available there. Even for sending requisition, government has issued specific instructions to the department that, all different departments, that while sending requisition forms to the NPC, the PIMs should be, that is one, that should be included. So that all further enforcement, everything will be done as per the PIMs. Even now, my PIM is active in the Soil and Water Conservation Department, it is still there. And then salary statement also we have sought for. There also, we say that we have appointed 3 persons on the recommendation of the NPC. But 4 posts are still lying vacant, even now also. And nobody has been appointed against these 2 posts. That is my case in brief, but let us go to the documents, how we were appointed, and in what manner we were terminated, and how we are justifying our case. Page 14. This is 3rd from 2016. As I have mentioned before, this is the appointment order of the petitioner as GSCO. Serial number 1 is the petitioner in WPC number item 14. That is WPC number 73 of 2024.
Serial number 1.
And serial number 2 is the present petitioner. That is WPC 52 of 2024. So, we were appointed on contract basis against the existing vacancies. Under the Soil and Water Conservation, in the scale of with the tip from the scale of under the condition number 2. The contract period is purely on temporary basis for a period of 6 months or till regular appointment is made by through NPC, which is made. This is a condition on which the government is pending. And then no right for regularization as is there, as usual in any other contractual appointment.
Yes.
Now, next page 15, annexure B. This is 9 October 2023. This is the last extension order. In continuation to this department's order, table number was dated 8 December 2022. The governor is pleased to extend the contract service of the following candidates to the post of GSU for a period of 1 year with effect from 1/10/2023 to 30/9/2024. So validity period is up to 30/9/2024. We were terminated before that on 12/3/2024. And in the condition number 2, as was mentioned in the appointment order, we have given the conditions that or till the regular appointment are met through NPSC, whichever is earlier. This condition was done. And in the clause 3, paragraph 3, this was issued with the clearance of the PNR department. And then the government has also approved. So PNR has considered my PIMS at the time of extending the admission also. They are fully aware. So at the time of requisition was done in 2021. That was done on 9/3/2021. In government affidavit at page 14 it is shown. As Lordship has noted that my extension order is up to 30th September 2024, but termination was done on 12/3/2024. And on this date, the date of termination of my service, the post held by me was not requisitioned to NPSC. That is my condition, because I have received the information for RTI and they have furnished all the information to us. Kindly come to the next page. These are with regard to the functioning of the duty, what type of duties I have been assigned, training, all this. Like any other regular employee, certificates are endorsed, so those may not be that relevant. So kindly come to page 26. This is 4th March 2022 order, where the office memorandum has been issued by the government for a comprehensive, by issuing comprehensive instructions on personal information management system, PINS. We will be concerned with paragraph 5, clause D, next page, that is page 27, and the top note you will find clause D. PINS registration is done on the basis of the following office memorandum and notifications issued by the PNR from time to time. And then 1 to 3 notifications which are relevant are shown. So for this purpose, I am referring to this clause D. And then kindly come to page 30. Page 30.
1 minute.
That is to show.
This OM of 4/3/22
Yes.
is also for contract ad hoc appointees also, isn't it?
Yes.
Okay, and page 30, 30.
Annexure H, that is the PINS. And then just above the search, with the total thing, my name is shown, H. Akapi Yabduni. And then down below, Lordship will find a column. There, it's written in small letters, but then particulars are given.
The
in this
PIMS code.
Yes, PIMS code. And department, my name, everything is shown, GSU, and then Tima posting has been shown, Tima. Next, Lordship, page 31 is the termination order, that is the appeal order, but before this, kindly come to page 32 first, because page 32 is 1st March 2022 24, and then page 31 is 12 March 2024. So in order to maintain the sequence, and also to show that on the basis of this recommendation, this termination has been issued. So can we come to page 32? Since this is the basis of the grammar, I may be allowed to read this entire order. This is 1st March 2024 by the Director of the Soil and Water Conservation Department, addressed to the Commissioner and Secretary, Governor of Nagaland. Subject: matters regarding the discontinuation, termination of contract service in respect of 2 GSCO and ultimatum given by SIDA. With reference to the subject stated above, I have to honor the forward theory and the ultimatum letter for termination of 2 GSU, namely Avili Naki and Sri H. Akavi Yutami, submitted by the Combined Technical Association of Nagaland for kind necessary action. I am also to advise you that 6 GSU were appointed by order with the dated 3rd June 2016 on contract basis for a period of 6 months, including Shri Avili Naki and Shri H. Akavi Yutami, against the requisition force to NPC. Whereas 4 of the GSU were discontinued terminated up to 1 year. However, the services of 2 GSU, Shri Avili Naki and Shri Sonso, has been extended from time to time till date against subsequent NPC requisitions, thereby inviting the unwanted confirmation with the SIDA many times. The SIDA, in their last ultimatum published in the newspaper on 18 February 2024, demanded the termination of this 2 GSU on or before 11 March 2024, and even caution to look down the Directorate Office on failing to act before the stipulated time, and also submitted ultimatum to our office on 26 February 2024. The terms and conditions in the appointment order and extension orders clearly mention that their appointment were purely on contract basis and that they have no right to claim regularization in any case and can be terminated at any time without prior notice or oversight. In the light of the above, the government may kindly take necessary measures and discontinue to terminate the services of this 2 GSU as and when the result of NPEC is declared in order to avoid further confusion in future. So my point is, this is the basis for terminating our service, not on any other ground, but there is a treaty by the SIDA to close down the directorate, who would like to close their own office. So with this alarm, he has sent proposal to the government to terminate our services, and government stand is, as I have mentioned, posts held by the petitioners have been requisition to the NPC, and recommended candidates had to be appointed in terms of the recommendation. So that was the condition, that is the condition of the government. But Lordship, in view of this letter, the services of the petitioners have been terminated. The entire basis is on the pressure of the SIDA, not any other business. And Lordship is very aware that even this morning Lordship has been expressing in one of the cases, this court cannot go into detail how decision is taken, how it should be taken, but the decision-making process can be examined by this honorable court under the basis, the process, how the decision was taken. That can be considered by this honorable court. Now I am coming to the immediate order. Based on the representation by the SIDA, the termination order is issued on 12 March 2024. And this was made effective from 7/3/2024 in view of declaration of result by notification dated 6 March 2024. 6 March the result was declared and it was made effective from 7 March 2024. And then name of the petitioner are shown in both the cases, they are the petitioners.
So you're saying that the posts which were requisitioned were not the posts being held by the petitioners.
So that is the sole contention of the government. So during the pendency of the petition, as I have been referring, we have filed an additional affidavit. This will be this will be the main basis of my case.
Additional
in
affidavit
support of the writ petition filed by the petitioner.
filed on 12/11/25.
Then it is written as in the subject index, particular additional affidavit in
In support of the,
writ
yes,
petition
yes,
filed by the petitioners.
yes.
When they come to paragraph 2, I will read only 4 paragraphs, and paragraphs are short.
Yes.
But the present additional affidavit is being filed with on the court certain factual clarification in response to the misstating and incorrect claims made by the respondents regarding the status of the post of tenure soil conservation officer and the post which was occupied by the incumbent petitioner and those occupied by the NPC qualified. 3. That the petitioner takes to state that, as per official records, till this of the NPC goes, the total sanction strength of GCO posts is 44. Out of this, 34 posts are presently occupied, and that out of the remaining 10 posts, 6 posts have already been requisitioned to the Nagaland Public Service Commission, and 4 posts are still lying vacant and unfilled. Those are the posts which petitioners are holding. As such, the claims made by the respondent that NPC recruits are entirely baseless and not supported by any official record. In order to show that, I have enclosed the document as Annexure X. What you will find at page 6. This is not very clear, but then I think it is written. This is October 2025. Under the Right to Information Act 2005. In response to your RTI application dated Kohima the 9/9/2025 and furnishing relevant and necessary information received from concerned branch of information sought by you pertaining to the serial number 1 to 3. Queries serial number 1 to 3. And then page 7. Top. The 10 days of employees appointed through NPSC from the year 2000 till date, that is October 2025. 2020 to October 2025, 14 persons were appointed. And there, 10 posts of GCO in the this designation also will find. Other posts are ranger, ARO, ranger. And rest are all GCO. So 10 posts have been requisitioned to NPC, apparently recommended and filled up from 2020 to October 2025.
Yes.
And then we have sought for a number of sanction posts in the second column, what you will find sanction posts. And then serial number 1, GSCO, sanction post is 44. So far, they have appointed 34. And then others are not necessary for us. Down below, the last hit note. List of post requisition sent to NPSC and vacancy available in the department. And then serial number 1, we are concerned with that. JSCO,
6.
requisition to NPSC 6, vacancy 4. So out of 10 posts, 6 to NPSC, 4 is lying vacant. Respondent is saying that remaining 4 posts as the requisition to NPSC in their reply. I will come to that at the relevant time. Now, next paragraph also. Paragraph 4, page 3. Same affidavit. That the petitioner further submits that they claim made by the respondent that the post held by the petitioner is already occupied entirely, is entirely baseless, not supported by any official record, and made without reference to a personal information system, management system, or any authenticated recommendation. It is pertinent to mention that as per the OM dated 566-7 Lordship, wrongly typed as 5/7/2019, while requisitioning post to NPSC Department Recruitment Board, it is mandatory for the department to indicate the name and the employee code of KIMS against each vacancy or enclose a copy to the post creation order in case of the new post in the requisition format. However, KIMS record for the period 2023 to 2025 categorically reflects that the GSCU posts are occupied as follows. And then one post of district social conservation office, one post of subdivision office, one post of subdivision office, one post of district soil conservation office, and one post of district soil conservation office, Oka. Therefore, the PIMS code of the petitioner is still untouched till date, which demonstrates that all along the post held by the petitioner is not touched or occupied by the NPSC deputies. And then annexure Y. These are the documents they have furnished. Persons appointed to GSO with effect from 18/10/2023 to 17/2/2025 on the recommendation of the NPSC have not appointed against the post held by the petitioners. So here, petitioner was appointed on 3/6/2016 and terminated on 12/3/2024. While extension was valid up to 39/2024. So here,
This annexure Y,
yes,
by this annexure, what are you trying to show? That, that
these
the
are the places where
other appointed, the NPC appointees.
recommended NPSC candidates were appointed.
Okay. So you're trying to show that this is not
This
your,
is shown.
that this is not against your PIMS code.
Yes, in short, that is the substance. Because common stand is that NPSC recommended candidates have filled up the post. So you are recommended. But those recommended candidates were appointed against those places, not against the post, the vacancy held by us, post held by us. So, lastly, the option again comes to paragraph. Thus, the petitioner further states that the GGOS incumbency salary statement also on 31/8/2025 for the district of Dimapur, Newland, and Jammu shows that only one post of GSCU is holding the field, which appears in serial number 13 of the city record. As such, the claims made by the respondent that the post held by the petitioner is occupied by the NPSC deputies are entirely baseless and not supported by any official record. Therefore, the legal termination order dated 12/3/2024 is arbitrary, discriminatory, and whimsical. And then annexure Z, page 14. This is the incumbency list, district-wise incumbency list of salary statement of the employees in Dimapur, Newland, and Jammu. Also on 3/8/2025. If the NPSC recommended candidates are appointed against the post held by me, the name should be figured in this list. But the post held by me does not mention. Therefore, the very basis of the government that the posts have been filled up by on the basis of the recommendation of the NPSC is baseless. So it is a big case where it is another court to scrutinize the arbitrary action of the respondents. The respondents will heavily come on the point that the posts have already been filled up. you might refer to the chart which I have enclosed in the additional affidavit at page 7 and 8, where the number of vacancies have been shown and the appointments were shown. There are two lists which is relevant, that is page 7, the list in page 7, the details of employees appointed for NPSC from the year 2020 till date. That is 1, up from serial number 1 to 14, and in the next page, serial number 1 to 34. This had a post of GSO, list of post requisitions sent to NPSC and vacancy available in the department. So 34 has been up to serial number 34 has been filled up by the recommended candidates of the NPSC. So absolutely there is no confusion. The names who are in the first chart in page number 7, their names are also there in the page number 8. So by no reasoning the government will justify about the basis of termination.
So your prayer in the writ petition is only to quash the termination order.
Yes, yes. Earlier petition was for calendarization, but then we thought it appropriate to withdraw it. To direct the respondent to raise the petition against the vacant sanction post. That is also there.
Service rules are there?
Yes.
Service rules. So as per the service rules, JSCO is direct recruitment post, I believe.
Yes. But that issue will come only on the ground when appointment is challenged. But in
Here
this petition-
it's only the termination,
Yes, termination, only the
the
termination.
basis of the termination.
Yes, very good.
Okay,
Any objection?
yes.
I think it will be more appropriate that petitioners will take first. It's all the
Okay,
same.
okay. So if any additional submissions,
Referring only to my additional affidavit, I've also filed an additional affidavit in my FPPC.
so yours is WPC
73 of 2020.
73.
So I'll be adopting the submission advanced by the SCA Council. What in facts as well as in law. Firstly, Lordship,
Additional affidavit.
the appointment, extension order, termination orders, all with that common orders passed
Common orders.
for the petitioner's Lordship. So I will not be referring to the appointment, extension as well as the termination. But just one aspect, Lordship, as far as the termination is concerned, it has mentioned that the NPC on termination is issued on the basis of the declaration of
Of the results.
And the date has been mentioned as 6 March 2024. So I'll be referring to that 6 March 2024. And this 6 March 2024 has been enclosed by the state in their affidavit. 6 March 2024.
Result, NPSC result.
Yes. Now this result, it declares for 3 posts. The result is pertaining to 3 posts. Notification dated 6 March 2024, it's pertaining to 3 posts. Now coming to the my additional affidavit, I have filed on 23rd of March 2026. Additional affidavit filed in the PPC number 73.
2nd March.
Yes, March 2026.
2nd March 2026. Yes.
23rd March 2026. May I come to the paragraph 4? Only from the because the first portion of the affidavit it talks about the RT application, and I'm also relying on the documents which was enclosed by the petitioner in the earlier petition. So So I'm using the same annexures, same documents as annexures. May I read this second portion of the affidavit?
Yes, yes.
It is stated that the petitioner was terminated from service purportedly on the ground that NPSC has declared this result white notification 6 March 2024, and which is marked as included at page 18 to the affidavit filed by the respondent number 1, 2, 3, and 4. Pursuant to a requisition for recruitment of 3 posts of JSCO, white letter dated 9/3/2021. This letter is also very important. This is the requisition letter. So, which is also marked as Annexure C, page number 12 of the affidavit of opposition filed by respondent number 1, 2, 3, and 4. If I may be allowed to refer to that document for a moment, page 12 in the affidavit filed by the state respondents, which was, I have received this on 21st of July 2024. There are 2 affidavits filed by the state respondents. The first affidavit, which was filed in the year 2024.
Yes.
May I take your lordship to page number 12, Annexure C. May I read it, lordship?
Yes.
This is dated 9 March 2021. To the Secretary and PSC Nagaland Kohima, submission of requisition of for recruitment of 3+2 gazetted posts under Soil and Water Conservation Department. With reference to the subject cited above, I am directed to submit herewith the requisition form duly filled in for recruitment, direct recruitment of the following posts. So and so, 3 posts of junior soil conservation officer. This is for your information and necessary action. So, along with this, there's only a typed copy, nothing more, nothing less. So, in other words, my respectful submission before this honorable court is, it is that the affidavit is silent on the PIMS number. They have not mentioned about PIMS number or posts which they have requisitioned. They have merely mentioned about only 3 posts requisitioned to the NPSC for filling up by way of a recruitment through the NPSC. So this I'll be relying on a notification issued by the PNR for as far as the PIMS is concerned. So this is the only document they have enclosed in the affidavit. Prior to the pursuant to this filing of an affidavit, they have also filed an additional affidavit. Nothing has been mentioned. Now coming to my additional affidavit portion. Page number 3, paragraph 4. May I continue working? If I may be allowed to continue from page number 4. Page number 4. On perusal of the PIMS portal, maintained by the maintained for the state government employees, it transpires that 3 employees, namely Shri so and so, their PIMS number so and so. This number is also very important. Mr. So and so, PIMS number so and so, and these are the 3 appointments. Along with the date is also mentioned. Date is 31st of March 2024, 8th of May 2024, and 17th of February 2025, respectively, for those 3 persons. And my PIMS I have already mentioned. After the petitioner's impugned termination order was issued, these appointment orders were issued after the termination order was issued, meaning thereby the petitioner's post, which service PIMS number so and so, -1084. Remains linked with the petitioner and the same is yet to be filled, which demonstrates that the state governments issued the impugned termination order without application of judicious mind. It was issued in a mechanical and routine manner, mainly on the ground that NPSC result has been declared. Such action has caused prejudice to the petitioner's fundamental and legal rights. Now coming to paragraph 5, I have enclosed a document. It is also stated that in terms of office memorandum dated 5th of July 2019, the state government has issued instruction to all departments that while requisitioning post to NPSC, it is mandatory for the department to indicate a name and employee code of PIMS. Against each vacancy or enclose a copy of the post creation order in the case of new posts in the requisition format. The absence of such compliance in the present case demonstrates that the post held by the petitioner was never part of any valid requisition. So, in other words, when the department has requisitioned to the MPSC for filling up this post, the 3 PIMS number which I have mentioned, if they have submitted, it will be only the 3 PIMS number, but not my PIMS number. It was left untouched. That is my respectful submission.
Have you enclosed any advertisements where such particulars are mentioned in the advertisement itself or in the requisition letter?
It should be in the requisition letter.
In the
Because in the
requisition letter.
advertisement, they don't normally publish the PIMS number. It will be only in the.
It should be in the requisition
Yes.
letter.
Now coming to the notification, which I have referred, page number 40, the last document, page number 40.
Page 15.
This is the office memorandum which
Yes.
I referred to 5th July. The relevant is
Yes.
the third.
Please read this.
PIMS, this is a personal information management system, is a web-enabled personal management system under the state government with the purpose of tracking and recording the service records of all government employees from the date of their joining in the service till they retire. In order to promote e-governance initiative and to provide transparency of the employee's profile, the state government has decided to make basic PIMS date public for the state government employees. All the public will be able to access the 10 select open fields of the government employees' profiles from the website of PIMS PNR department by logging in at www. Discrepancies in data, if any, must be brought to the notice PNR department to the concerned department nodal officer only. So the first two paragraphs states about the necessity of the PIMS, and now the third. It is also informed that departments while requisitioning posts to NPSC, Departmental Recruitment Board, should indicate the name and employee place of new post in the requisition format. The NPSC or DRB in turn must use the same code while making recommendations for appointment to the department concerned. It also reiterated to all departments that all service-related orders issued by any department such as appointment, transfer and posting, promotion, retirement orders must reflect the PIMS code of the employee, and a copy must be endorsed to the PIMS PNR department. It is also observed that many new head of the departments need to get themselves familiarized with PIMS for better governance and maintenance of the department's employee. Utilizing the system, the PIMS in each directorate should also be strengthened, and the nodal office in charge of the system should ensure that the employees' data are up to date in the system. Further, as per OM so-and-so, appointment on contract basis, ad hoc fees so-and-so, a bank so-and-so. However, many departments still so-and-so, sending such proposals for registering the PIMS and defining so-and-so. It is therefore reiterated that the PIMS shall not entertain such appointment for registration. But as far as the petitioners are concerned, they were appointed before this notification of 6/6/2016, which is why they were given the PIMS number. Now coming to the information provided by the department, page 8, so the Senate Council for Petitioner has also referred to this notification.
Yes.
Page 8.
The same one, that RTI
Yes.
information.
So the total strength of the posts, sanction posts, 44, and 34 feet, 10 were lying vacant. 10 were lying vacant. And only 3 posts were freed. Only 3 posts were freed. And as far as the petitioner's PIMS number is concerned, you also will find a page number 13.
Yes. 1084.
Yes, 1084. Therefore, my respectful situation is just because the NPSC has declared the result, they get a randomly generated meaningful service. And this PIMS number and all this information were provided only after the determination issue, order was issued, after the results were declared. So the 3 appointments which were made, it was against other
If your post is advertised, of course, you do not have a right to continue if the NPC's results are declared. But
the 10 posts were lying vacant at the relevant point in time.
okay. Yes.
May I please, my lord?
It appears that the posts which are advertised did not belong to the petitioners.
Yes.
Were not held by the petitioners.
That is the only issue, Your Lordship, here to be decided. As far as the PIMs and all are concerned, Your Lordship knows 100 times better than me as far as those PIMs are concerned, because there are temporary PIMs which are issued to the work charge employees, then there are regular PIMs which are issued. So the issue of PIMs is not here, Your Lordship. The only issue is whether the post has been recusation to the MPAC or not, Your Lordship. That's the only issue. So, Your Lordship, to make my submission, if I may
No,
be allowed.
but do you deny that you are not holding sanctioned posts? They are appointed against sanctioned posts, isn't it?
On a contract basis against a
But
post.
against sanctioned posts.
Yes, against a post which is supposed to be recusation to MPAC.
True, but
Yes.
true, but the appointment is against the sanctioned posts.
Yes.
Even if contractual.
Yes, it's against a sanctioned post on a contractual basis, but for only for that period when the post has not been regularly filled up through MPAC.
True, that's understood, of course.
Yes, yes. My Lord, may kindly come to page 10 of my affidavit. I just wanted, of course, my little senior friend has gone through it. I just wanted to show.
You have filed a similar affidavit?
Yes. More or less similar, a little different here and there, my Lord. I'm referring to the.
So now you're referring to?
Yeah, filing WPC 52, my Lord.
Okay. Yes, 1 to 4.
Yes. Your Lordship,
Yes.
if I may be allowed to read this, Your Lordship, and then I would like to refer to one this thing here. Your Lordship, it says the orders dated 3/6/2016, in the interest of public service, the governor is pleased to appoint the following
Now, where are
candidates.
you reading from?
Page 10, my Lord.
Page 10.
Yes. This is the appointment order of both the petitions.
Yes, we have
Yes.
seen.
Yes.
Page 10.
Page 10.
Yes.
In the interest of public service, the governor is pleased to appoint the following candidates for the post of GSO, ASO on contract basis against the existing vacancy under the soil and water conservation with immediate effects in a pay scale of such and such, plus all other allowances admissible in the rules in Nagaland from time to time with effect from the date of taking charge. Your Lordship, there is a chart. Your Lordship may kindly come to chart number 4. First chart is serial number, the name, then designation, then against the vacancy. It says recusation post of MPAC. And therefore, para 2 flows from it. Para 2, which says the contract period is purely on temporary basis for a period of 6 months, or Your Lordship, till regular appointment is made by MPAC, whichever is earlier, my Lord. Now, the terms and conditions prescribed herein clearly indicates that the post has to be filled up through direct recruitment by the examinations conducted by the Nagaland Public Service Commission.
That they are also not denying.
Yes. Then, Your Lordship, since the post has to be recusation to MPAC, Your Lordship may come to the next page. This is by a letter dated 3rd of March 2021. The Directorate of Soil and Water Conservation has written it to the government for recusationing of the post, Your Lordship. Your Lordship, the type copy you'll find it page 12. Subject.
Yes, submission of recusation.
Submissions of recusations for appointment of Class 2 gazetted officers under Soil and Water Conservation. Here, Your Lordship. Sir, in inviting to the reference subject, I have the honor to submit herewith the recusation of 3 posts of Class 2 gazetted officers in a pay scale for direct recruitment through Nagaland Public Service Commission. Necessary formats are duly filled in Annexure A and B. Now, these formats are already sent to the MPAC, Your Lordship. But here it says necessary formats are filled up in Annexure A and B for counter signature and onward submission to the Commission for direct recruitment. So whatever necessary things are there, it has been there in Annexure A and B along with this particular recusation letter, my Lord. Then, Your Lordship, on receipt of this letter from the Directorate, Your Lordship, the government has by a letter dated 9th of March 2021, Your Lordship will find that on the next page, there is page 13. Your Lordship, I wanted my Lord to note down this date, 9/3/2021, because this is very important, my Lord. Yes, Your Lordship, this is a requisition letter to the MPSC by the government. Type copy, Your Lordship will find it on the next page. 2021, 9/3/2021, my Lord. 9/3/2021. Your Lordship, type copy on the next page. Subject, submissions of requisitions for recruitment of 3 Class 2 gazetted posts under Soil and Water Conservation Department. Sir, with reference to the subject cited above, I am directed to submit herewith the requisition form duly filled in for direct recruitment of the following posts in the pay matrix such and such under Soil and Water Conservation, along with annexure A and B, Your Lordship, again. Along with annexure A and B, and the 3 posts are mentioned, clearly mentioned as Junior Soil Conservation Officer, JSCO. Your Lordship.
Okay.
Yes. Now, Your Lordship, the Nagaland Public Service Commission has issued an advertisement, and basing on the marks that have been obtained by the candidates, Your Lordship, on written as well as on an oral interview and on merits, recommended the names of the candidates for appointment, Your Lordship. The 3 posts that has been requisitioned by the department to the Nagaland Public Service Commission, Your Lordship will find it on page 24. Page 24. Three posts of Junior Soil Conservation Officer Class 2 gazetted under Soil and Water Conservation Department. Now, Your Lordship, before going that, let me refer the notification, the first para, page 17, the result. Notifications.
Yes.
So yes, in pursuance of the Nagaland Public Service Commission, this notification dated 6th of March 2024, Your Lordship. In pursuance of the Nagaland Public Service Commission, advertisement number such and such, dated 29/4/2023, addendum corrigendum dated 2/5/2023, addendum dated 10/5/2023, and addendum dated 24/5/2023. The Commission, on the basis of the aggregate mark obtained in written examination and viva voce, is pleased to recommend the following candidates in order of merit for appointment to the various posts under the government of Nagaland. So it is on the basis of that advertisement and on the basis of the marks obtained and on merit, these 3 individuals were appointed against the post that has been requisitions to MPSC, Your Lordship. Now, Your Lordship, the petitioner, counsel for the petitioner has been stating that the department has terminated the petitioner due to the pressure imposed upon the department by an organization that is known as CTA. And I wanted to refer to that particular letter again, Your Lordship, and I wanted to point out something here, my Lord. Your Lordship may kindly come to page 32 of the writ petition.
Yes.
Your Lordship, I'll just refer the 3 paras only. The first para is not relevant, Your Lordship. There are 3 paras, starting from the second para, my Lord. I am to apprise you that 6 JSCOs were appointed via order dated 3/6/2016. This is appointment order, Your Lordship, of the petitioner's concern, on a contract basis for a period of 6 months, including Sri such and such and Sri such and such against the requisition post of MPSC, whereas 4 JSCOs were discontinued, terminated after 1 year. However, the service of 2 JSCOs, Sri such and Sri such, these are the name of the petitioners, my Lord, has been extended from time to time till date against subsequent MPSC requisitions. Against subsequent MPSC requisitions, Lordship. Thereby inviting the unwanted confrontation with the Combined Technical Associations of Nagaland, CTA, and many times the CTAN in their last ultimatum published in newspapers on 18th of February 2024 demanded the terminations of 2 JSCOs on or before 11th of March 2024 and even cautions to lock down the Directorate Office on failing to act before the stipulated time and also this submitted ultimatum to our office on 26th of February 2024. The terms and conditions in the appointment orders and extensions orders clearly mention that the appointments were purely on contract basis and that they have no right to claim for regularization in any case and can be terminated any time prior without prior notice from either side. Now the next line is important, my lord. In the light of the above, the government may kindly take necessary measures and discontinue, terminate the service of these 2 JCOs as and when the result, your lordship, as and when the result of the MPSC is declared in order to avoid further confrontation in future. Why was such statement made, your lordship? Because the post has already been recusation to MPSC, which has been mentioned in para 2. And therefore, the director is asking the government to terminate these 2 as and when the result is declared by the MPSC. Your lordship. And this is dated, my lord, 1st of March 2024. Your lordship may kindly come to the previous page. This is dated 12th of March 2024. Your lordship may...
Director's letter is
Yes,
March
1st of March 2024. Your lordship may kindly allow me to add one more submission as far as this letter dated 1st of March 2024 is concerned. Your lordship, para first and second para is the facts that have been narrated by the director to the government as to what has been happening. And third, the final para is a request made. And the request is to terminate them because the directorate has got no authority to terminate and therefore is asking the government to terminate them as and when the result of the MPSC is declared. Very clear, my lord. Very clear. Then, your lordship, the previous page. This is the impugned termination order. This is the notifications dated 12th of March 2024. If I may be allowed to read this, my lord.
Yes.
Notifications dated 12th of March 2024. In continuations of this department order of even number dated 9th of October 2023, terms and conditions therein, the governor of Nagaland is pleased to terminate the contract service of the following JCOs with effect from 7/3/2024 in view of the declarations of MPSC result via its notifications dated 6/3/2024. Now, this is the date where the result has been declared by notifications by the MPSC through these notifications, my lord. Now, this, your lordship, from all this document, it is very clear that the post held by the petitioners on contract basis has already been recusations to MPSC. However, your lordship, allow me to take...
But the documents do not show that it is
Yes.
that post.
Yes, your lordship. Therefore, your lordship, I will take my lordship to that page, to that particular notifications. Your lordship may come to my affidavit in opposition again.
Yes.
On last page, page 34, annexure I.
Yes.
Now, this is an extension order. If I may be allowed to read, your lordship. This is order dated 22nd of June 2022. In continuations of this department order of even number dated 23rd of September 2021, the governor is pleased to extend the contract service of the following candidates to the post of JCO for a period of 6 months with effect from 1/4/2022. So the name of the petitions are reflected. Number 2, the contract period is purely on temporary basis for a period of 6 months. 3, this is important, my lord.
the posts of the incumbent are already sent for requisitions to MPAC via letter number such and such and 9/3/2021. That is why, Your Lordship, I was saying, this requisition letter, that 9/3/2021 is important. Hence, once the post is recruited through MPAC, the incumbent will be terminated automatically. Clearly mentioned, my lord. So the letter 9/3/2021, against which 3 posts has been requisitioned 5/2020, and another 2 is 9/3/2021.
So their posts were requisitioned on
Yes,
9/3/2021.
2021. The requisition letter 9/3/2021 of the government requisitioning the post to MPSC for direct recruitment pertains to their post. Therefore, it is being clearly mentioned. And also it says, hence, once the post is recruited through MPSC, the incumbent will be terminated automatically. Automatically, my lord. So there is no question, Your Lordship. There is no question as to whether the post has been requisitioned to MPSC or not. There is no question about this. Cannot be any dispute on this issue, Your Lordship.
What about the PIMS code?
Your Lordship, PIMS code, as I said, it is a little embarrassing to...
Because against each post, there will be a particular PIMS code.
Yes. But Your Lordship, for PIMS code, Your Lordship, PIMS, Your Lordship, as I said, even for temporary employees, PIMS are
Temporary
generated.
PIMS is there,
Yes,
different.
are generated. And for a regular post also, PIMS are generated. For instance, Your Lordship, it is embarrassing for me to say this, but let me take my own example instead of taking others' example. Let me take my own examples. I don't have a sanctioned post, but my posts are required posts, and therefore I have a PIM. And therefore, since I have a PIM, Your Lordship, can I come to this court and say, like, look, the PNR has generated a PIM for me, and therefore now my service has to be regularized? Or, for that matter, if I'm terminated, can I come back to this court and say, since I've been given a PIM, I'm considered as a regular employee, I should be considered as a regular employee, and therefore my termination should not have been caused. Can I say that, my lord? No. PIMS, Your Lordship, PIMS, even for work charge employees, PIMS are there. PIMS are generated mainly because of e-transaction. Your Lordship knows that. Your Lordship knows 100 times better than me when it comes to that. It is just for e-transaction. Because the government has
For the
stopped.
pay.
Yeah, for the pay purpose only. It is nothing else, my lord. It is nothing else, Your Lordship. And therefore, from this document order dated 22/6/2022, Your Lordship, there can be no dispute as to whether the post held by the petitioners has been requisitioned to MPSC or not. Furthermore, Your Lordship, since my another senior friends has been, and of course my other friend here also in other read petition, has been submitting on the RTI reply. Your Lordship, from this RTI reply itself, it shows that the post, there is no vacancy. All the posts of JSCO, Your Lordship, are either requisition to the MPSC or on the process of requisition to the MPSC. Your Lordship may kindly come to page 7. Page 7 of the additional affidavit filed by the petitioner.
According to the RTI reply,
Yes.
6 posts were requisitioned,
Yes.
and there are 4 vacancies.
4 post vacancy. Now, Your Lordship, before that, Your Lordship, on the first, just above that para, sanction strength.
44.
Sanction strength. Your Lordship may see, sanction strength, JSCO is 44.
44, yes.
Your Lordship may kindly come to page 8. Your Lordship will find that up to serial number 34. there are GSCO. 34. So total strength is 44, my lord.
44,
Yes, 34 is here. 6 has been requisitions to MPSC. 4 is vacant. So that makes it to 44, the total strength. What has happened to these 4 posts, your lordship? I'll just give my explanation, submission on this, your lordship. Your lordship, can you come to my reply to the additional affidavit?
Affidavit in reply.
Yes.
Okay.
Your lordship may see that the reply was given to the petitioner on 6th of October 2025. Now this 4 vacancy, the 4 vacancy has arose due to the promotions of 4 incumbent JSCO. Your lordship will find that at page 5. Page 5. Page 5 of my reply, your lordship. Page 5. Notifications dated 19th of February 2025, my lord. If I'm, yes.
Okay, so these 4 posts
Yes.
are promotional posts.
Are promotional.
Created by promotion.
Yes, are created by promotion, your lordship. If I may be allowed to read this, my lord. Notifications dated 19th of February 2025. In the interest of public service and on the recommendations of the Departmental Promotion Committee held on 19/2/2025, the Governor of Nagaland is pleased to order the promotions of the following officers under soil and water conservation with effect from the date as under. Your lordship, we are concerned with serial number 3 and 4. 3 and 4. So they are promoted to SSO. Then, your lordship, on the next page. On the next page, page 6. Again, another notifications, 11th of September 2025. Your lordship, I may be allowed to read this again, my lord. Notifications dated 11th of September 2025. In recommendations of the Departmental Promotion Committee held on 10/9/2025, the Governor of Nagaland is pleased to order the regularization promotion as under. Your lordship, we are concerned with serial number 5 and 6. Soil commiss and next SSO, promoted to SSO.
So these are also from JSCO.
JSCO, your lordship. Your lordship, to support my submission, your lordship, I can place a document, though of course it is through WhatsApp they have given it to me. It's not quite clear, but the names can be clearly seen, my lord. This is, your lordship, a service confirmation order. The order dated 31st of March 2022, the following officers under Soil and Water Conservation Department are hereby confirmed against their permanent post with effect from the date of joining. Your lordship, we are concerned with serial number 9, 10, 11, and 12. These are the 4. And your lordship, confirmed post is, your lordship will see that it is JSCO. So from JSCO, they were promoted, your lordship. So all of them were JSCO, my lord. Your lordship, the notifications 11 September 2025, the name of the two persons, serial number 5 and 6, Your Lordship will find it at serial number 9 and 9 and 10, and by notifications 19 February, Your Lordship will find that the names are reflected as serial number 11 and 12.
No. Their names are different.
No, Your Lordship. I'm sorry, 11, serial number 7. 7.
Yes. Serial number
7 and 8. 7 and 8.
7 and 8.
8
and
and 9 and 10, Your
and
Lordship.
10.
Yes. So the 4 post vacancy that has been mentioned in the RTR reply pertains to this vacancy
So
post.
according to you,
Yes.
out of this 44,
Yes.
34 already filled up
Fill
by
up.
PSC,
Yes.
then 6 requisitioned,
Yes.
and now these 4 vacancies will
Yes.
have arisen due to the promotion of 4 JCOs.
Correct. And that 4 posts also, Your Lordship,
Requisitioned.
it has already been, a requisition has already been sent. Your Lordship will find it on the next page, page 7. By a notifications, by a letter dated 9th of December 2025. May I read this, my lord? Submission, subject, submissions of requisitions for direct recruitment of Class 2 Gazetted Under Soil and Water Conservation Department. Madam, in inviting a reference to the subject cited above, I have the honor to submit herewith the requisition for appointment of 4 posts of JCO, Class 2 officer, on pay level such as such for direct recruitment through Nagaland Public Service Commission. This has the approval of clause on the PNR, PM cell, the numbers that here necessary, again say, my lord, here, hence necessary format are duly filled up in annexure A, B, and 1 for counter signature and onward submissions to the Commission for Direct Recruitment. So the 4 posts also has already been requisition, Your Lordship. Now, even from this reply,
Yes.
even from the reply of the RTI, clearly shows that the total strength has already been filled up or going to be filled up by recruitment through Nagaland Public Service Commission. There is no post, Your Lordship, vacant. There is no post. All the post that has been occupied by the petitioner on a contract basis has already been requisition that I have already shown it, Your Lordship, in the form of the orders. And therefore, Your Lordship, here, to the prayer of the petitioner to quash and set aside the termination order does not arise, to reinstate them, Your Lordship, also does not arise, because where will the petitioner be reinstated when the post itself has been requisitioned to the Nagaland Public Service Commission, my lord? So it's very clear, my lord.
Okay.
I'm deeply obliged, my lord.
Short reply will be necessary because Alana has tried to mix up the number of posts, declaration, but this appears to be very confusing, so I will verify that. But before coming to that, first thing first, with regard to the FTI list, Alana friend has been trying to distinguish between the permanent
Permanent beams and temporary beams.
Then we come to my additional affidavit in reply by the petitioner. Affidavit in reply by the petitioner. Page 10.
1 minute.
That is in office memorandum of 5th July 2019.
Affidavit in reply.
Affidavit
In reply by the affidavit in,
format has been changed in such a way that very confusing.
it is
Even
very
the
confusing.
juniors are also not reflecting in detail.
Affidavit in reply,
By looking at the front page, we can make out, but then it is not prepared in that manner, which is very confusing.
affidavit in reply to the additional affidavit of the petitioner. No, this is one, two.
Affidavit in reply against the affidavit in opposition filed by respondent number 1 to 4. In other words, against the common affidavit.
Okay, affidavit in reply filed for and on behalf of the petitioner to the affidavit in opposition filed on behalf of 1, 2, and 3. 1, 2, 3, and 4. I think this is the
My
one.
affidavit is 1 to 4.
The WP 73.
No, 52.
Oh, 52.
No, 52.
Yes, that's right. Affidavit in reply in support of the writ petition. Petitioners. Affidavit in reply to the addition to the of the 1 to 4. Yes.
Page 10, on the issue of temporary, permanent,
Page 10. Yes.
Page 10, paragraph 5. Further, as per the office memorandum number 66/2016, appointments on contract basis, the top fixed schedule, work chart, etc. are banned with effect from 6 June 2016. However, many, focusing on this, however, many departments are still sending such proposals for registering in the PIMS in details to the state office memorandum. It is therefore being cleared that the PIMS seal shall not entertain such appointments for registration. Just to show that, yes, in case of common advocates who are not treated as common servants, they can also get PIMS, then only they will get the general fee and whatnot.
No, even our peons who are on fixed pay, they are also getting this PIMS code,
Yes.
temporary PIMS
That
code.
is for payment of salary only. But the manner how our PIMS has been registered is in such a manner that we are regular appointees. Not regular contract, but then against a sanction post. My learned friend has referred to so many factual aspects, but the basic issue which the press is with regard to the basis of decision making. My learned friend has been showing the sequence, how the director has written and when the government has taken the decision, how termination order was issued. That is an organization, not the daily wages. They are highly qualified and they are looking for employment and services. Therefore, they are meticulously following what are the developments going on in each and every department and so also in the NPC. They are not ignorant about the declaration of result with the NPC. And they are aware about the conduct of the examination by the NPC. So with all these calculations, they have been waiting to take the best chance, best opportunity. Until the time has come for declaration of the result, they are anticipating all these. Therefore, they have submitted the representation to the director, and the director's letter is very clear who has proposed for termination. What is the reason given?
See, this court only has to see whether it is your post which has actually been requisitioned.
Yes.
And if the court finds that it is your post, then you have no right to continue.
Yes.
you are a contractual appointee, that is not denied, and appointed against a post which is a direct recruitment post. That is, so that is the only limited ground. Whether it is your post which has been requisitioned or not. That's all.
By referring to the addition affidavit, I have shown the list of post requisitions sent to NPSC
That we have seen,
and the
yes.
vacancies available in the department, page 7, last paragraph. And then annexure 1 is given. What you will find here, JSU, only 24 posts. And the sanction post is 44. Total sanction strength. Sanction post is.
So that's why the government advocate has said that 34 posts, 34 posts are now held by officers recruited through NPSC, and 6 already requisitioned now, and 4 vacancies were there which has already been requisitioned also.
That is what. But the basis of our termination is prior to that. So we are questioning the basis of decision making. If you have filled up the post by the candidates who are recommended by the NPSC, then how there can be another requisition against the same post? That is the condition of the government. And the requisition was 9 November 2025. After they have replied the RTI, requisition to NPSC was on 9/11/2025.
9/12/2025.
Yes, 9/12/2025. And we are talking about prior to that. Because they have furnished the RTI in the month of October 2025.
When did these vacancies arise? But that we have to see.
That's why.
These 4 vacancies.
That's why when they have furnished the
Those
information,
promotional vacancies,
have
they
already-
arose in September 2025. September, 1 arose, 2 arose in February, September 25. Out of those 4.
Yes.
so to complete the menu, my reply are paragraph 4, 10, 11 and 14.
4, 10,
11 and 14.
4, 10, 11 and 14.
I am citing through that one. 2011.
This 4, 10, 11 and 14 is in your reply affidavit.
Yes, yes. Affidavit will apply. Against the affidavit in opposition, 5 were responded number 1 before. First statement also, 2011, 15 is CC, page 16. I will refer only 2 paragraphs. That is paragraph 25 and 28. Paragraph 25, as you also read.
Yes.
Yeah. It is true that judicial review of matters that fall in the realm of
Contracts.
contracts is also available before the federal court, but the scope of any such review is not all pervasive. It does not extend to the court, substituting its own view for that taken by the decision-making authority. Judicial review and resultant indifference is permissible, where the action of the authority is made nullified, arbitrary, irrational, disproportionate, or unreasonable, but impermissible if the petitioner's challenge is based only on the ground that the view taken by the authority may be less reasonable than what is possible alternative. The legal position is civil that judicial review is not for much concern with the correctness of the ultimate decision as it is with the decision-making process.
unless, of course, the decision itself is so perverse or irrational or in such authoritative terms of logic that the persons taking the decision can be said to have taken leave on his senses. And paragraph 28. Recognizing the difference between the public and private law activities of the state, the court reasoned that, unlike private individuals, the state, while exercising its power and discharging its functions, acts for public good and in public interest. Consequently, every state action has an impact on the public interest, which would in turn bring in the minimal requirement of public law applications in the discharge of such functions. The court declared that, to the extent the challenge to state action is made on the ground of being arbitrary, unfair, and unreasonable, hence, offensive to Article 14 of the Constitution, judicial review is permissible. The fact that disputes still within the domain of contractual application did not declare this court relieve the state of its application to comply with the basic requirements of Article 14. That is on Article 14, which is one of the grounds which we have taken is violation of principles of natural justice. And the second judgment is 2024 ECC online 3826. It was decided on 20th December 2024. Chief is aware about Jagu's case. I will refer to 5 paragraphs. Paragraph 7, 21, 26, 27, and 28. So let us go to paragraph 7 to know the background. They urge the High Court to recognize their long and continuous service, the nature of their work, and the lack of any backdoor or illegal entry. He highlighted that they had functioned without any break, performed tasks equivalent to regular employees, and had been assigned duties essential to the regular upkeep, cleanliness, and maintenance of the respondent's office. The High Court, after examining the tribunal's decision and the submissions at once, concluded that the petitioners before it were part-time workers who had not been appointed against sanctioned posts, nor had they performed a sufficient duration of full-time service to satisfy the criteria of regularization. It is relied on the principle laid down in the Secretary of the Somadini's case, holding that the petitioners could not claim a vested right to be absorbed on regular without fulfilling the requisite conditions. The High Court further observed that the petitioners did not possess the minimum educational qualifications ordinarily required for regular appointments, and additionally noted that the employer had subsequently outsourced the relevant housekeeping and maintenance activities, concluding that there was no legal basis to grant the relief sought. The High Court dismissed the petition. Aggrieved by this rejection, the appellant had approached this court by way of present appeals. That is the background how the appeal has been filed. Paragraph 21. The High Court placed under emphasis on the initial level of the appellant's engagement and the outsourcing decision taken after their dismissal. Courts must look beyond the surface level and consider the realities of employment, continuous long-term service, indispensable duties, and absence of any malafide or illegalities in their opportunities. In that light, refusing regularization simply because their original terms did not explicitly state so, or because an outsourcing policy was relatively introduced, would be contrary to principles of fairness and equity. And then paragraph 26. With the judgment, the normative sovereign sought to curtail the practice of backdoor entries and ensure appointments adhered to constitutional principles.
it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long-serving employees. The judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in irregular appointments who were engaged in a duly sanctioned post and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the notable interest in the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claim of employees. Even in the cases where the appointments were not illegal but merely lacked adherence to procedural formalities, government departments often cite the judgment in Umadibis to argue that no vested right to regularize exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. The selective applications distorts the judgment's spirit and purpose, effectively organizing it against employees who have rendered indispensable services over the decades. 27. In the light of these considerations, in our opinion, it is imperative for government departments to let an example in providing fair and stable employment, encouraging workers on a temporary basis for extended periods, especially when their rules are integral to the organization's functioning, not only contravenes international labor standards, but also expresses the organizations to legal challenges and undermines employees' morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principles of justice and fairness, and that they are meant to embody. This approach aligns with international standards and sets a positive precedent for the private sector to follow, thereby contributing to the overall betterment of labor practices in the country. In view of the above discussions and findings, these appeals are allowed. The interim orders passed by the High Court and the tribunals are set aside, and the original application is allowed to the following extent. And then how it was allowed to discuss. 1. Termination orders dated 27th day 2018 are quashed. The appellant shall be taken back on duty forthwith and their services regularized forthwith. However, the appellant shall not be entitled to any pecuniary benefits, back wages, for a period they have not worked for, but would be entitled to continue in service for the same period, and the same would be counted for their post-retirement benefits. So, in the light of all these judgments, should be considered the background of appointment, continuation, and termination, and the basis of the government. Alia,
Learned Senior Counsel, Mr. Sidi Jamir, assisted by Mr. Anba Wazikam for the petitioners. In WPC 52 of 2024, so I've also heard Mr. Moa Jamir for the petitioner in WPC 73 of 2024. So heard Learned Senior Government Advocate Mr. N. Angami for the state respondents. Hearing is concluded, judgment reserved.
For hearing, item numbers 16 and 17.
Lords, they have filed revision, Lords, against the discharge order, Lords. But they are not here, Lords. On the last time, Lords, clearly it was stated in the order sheet, Lords. I am reading the last, Lords. Have you heard?
You are appearing for the CBI?
No, Lords. I am for the respondent, Lords.
Okay.
Lords.
Oh, but it is filed by CBI is the petition.
Yes, Lords. CBI, Lords. I was discharged by the trial court, Lords. They have filed against that, Lord, the revision, Lords. And the last and
No
final
one mentioned, but yesterday someone mentioned on behalf of the PP that he broke his leg. So a mention was made in one case to list the matter after 3 weeks on behalf of the same PP who is appearing in this matter. But now,
My Lords. Then, Lords,
I understand you have come from outside,
My
but
Lords. Then Lords may have it after vacations, Lords, because I think Lords his leg has been broken, so at least.
So
if
that's why they asked for 4 weeks. He has not sprain, it's a fracture. He had fractured his leg.
My Lords. Then Lords,
After vacation would be when?
Lords, can it be 3rd of August? Lords are there after Lords.
3rd of August.
Third. Lords, I'm checking my diary also, Lords, so that I can manage here and there also, Lords.
Okay, 3rd of August. Learned PP for the petitioner, Mr. Pandangwa Bang, is stated to have some medical problems today. So the learned counsel, Mr. Your name?
DK Pandey, Lords.
D.K. Pandey, appearing for the respondents, prays that the matter may be listed on 3rd August 2024, as he is an outstation counsel and the said date would be convenient for him. So accordingly, the prayer is allowed, list on 3/8/2024 for hearing.
My Lords, highly pleased, Lords.
Andavra, Asilani,